Hey everyone, welcome to This Explainer. If you've ever wondered how just a few simple words can lock you into a binding legal agreement, or conversely, completely failed to do so, well, you are absolutely in the right place. Today, we're diving straight into the Indian Contract Act of 1872 to unpack what is arguably one of the most famous legal mysteries of the 19th century, the classic 1893 case of Harvey versus Facey. Let's see how a seemingly harmless exchange of messages actually made legal history. So think about this. Can a single telegram actually create a legally binding contract? To really find the answer, we have to look super closely at the exact words exchanged between two men who were negotiating over a piece of real estate. As you'll see, in contract law, the difference between a casual chat and a hardcore legally binding obligation basically comes down to a razor-thin margin of intent. All right, here's our agenda for this explainer. First, the bumper hall pen dispute. Second, Section 2A, defining offers. Third, information versus legal offers. Fourth, the court's ratio decidendi. And finally, test your legal knowledge. Okay, Section 1, the bumper hall pen dispute, a 19th century legal mystery. So, setting the scene. The year is 1893. Our two main characters, Mr. Harvey and Mr. Facey, are communicating over a very uniquely named piece of property called Bumper Hall Pen. Harvey decides to send Facey a telegram just to get the ball rolling. Will you sell us Bumper Hall Pen? Telegraph lowest cash price. Now pay close attention because Harvey is actually asking two completely distinct questions here. Question 1, are you willing to sell? And question 2, what is your absolute bottom line price? Keep those two separate questions in the back of your mind. So Facey receives the telegram and fires back a quick reply. He writes, lowest price for Bumper Hall Pen, £900. But wait, notice anything missing? Facey completely ignored that first question. He never explicitly stated whether he was actually willing to sell the property to Harvey. He literally only answered the second part of the inquiry, just giving him the price point of £900. But you see, Harvey read that telegram and immediately assumed a deal was struck. He fired back a third telegram stating, we agree to buy Bumper Hall Pen for £900. Harvey basically thought Facey's statement of the price was an official offer to sell, and that by saying we agreed to buy, he had officially accepted it, sealing the deal. But when Facey later refused to sell the property, Harvey took him to court, and boom, a massive legal dispute was born. So, who was legally right? Let's move to Section 2. Section 2A, defining offers under the Indian Contract Act of 1872. Even though this was originally an English common law case, its core principles perfectly illustrate the framework we use to analyze disputes exactly like this one. All right, under Section 10 of the Act, establishing a valid contract is like climbing a ladder. It requires a strict sequence of events. Step 1 requires a valid offer. Step 2 requires a valid acceptance of that specific offer. Only then do you reach Step 3, a valid contract. A legally binding agreement is just entirely impossible if you trip up on the very first step. No offer, the whole process completely derails. And this brings us to the actual legal definition of an offer, or a proposal, as it's formally called in Section 2A of the Act. A proposal is made when one person signifies to another a willingness to do or abstain from doing something to obtain their assent. The absolute key phrase here, the one you really need to remember, is willingness to do something. Facey had to express a clear willingness to actually sell the property. So did simply stating a price of £900 signify a willingness to sell? To answer that, we arrive at Section 3, information versus legal offers, where intention is everything. This is really the core dichotomy of the whole case, separating just a casual chat from a legally binding promise. There is just a massive difference between supplying information and making a true offer. Supplying information sounds exactly like lowest price, £900. It's just a data point, right? A legal offer, on the other hand, sounds like, I offer to sell you this for £900. Facey's telegram fell firmly into that first category. He was just answering a factual question about the price tag, without any documented intent to actually be bound to a sale. Let's move to Section 4, the court's ratio decidendi, examining the Privy Council ruling. Now, the court ultimately decided in favor of Mr. Facey. But as students of the law, we usually care a little less about who won, and a whole lot more about why they won. This underlying reason for the court's decision is what's called the ratio decidendi. The ruling established that communicating the lowest price is merely the supply of information, not a valid offer. And exactly as we learned from our step-by-step ladder sequence earlier, without an offer, no contract is formed. A price tag all by itself lacks that vital Section 2A requirement. It doesn't express a clear willingness to be bound. All right, let's switch gears for Section 5. Test your legal knowledge. Let's enthusiastically apply what we've just learned to 3 quick scenarios. Okay, question number 1. Think about this. Does quoting the lowest cash price of a property automatically create a legally binding offer? Think back to Mr. Facey's little telegram.
The answer? Absolutely not. No. A mere statement of price is legally distinct from an offer. It is simply the supply of information. This is literally the ultimate takeaway from the Harvey versus Facey ruling. Just because someone tells you how much something costs definitely doesn't mean they're actively offering to sell it to you.
Let's try question number 2. Under Section 2A of the Indian Contract Act, what crucial element absolutely must exist for a communication considered a valid proposal? Think back to that definition we analyzed a minute ago. If you guessed intention, you hit the nail on the head. The intention to create a binding proposal is required, a clear expression of willingness to be bound if the other party accepts. Intention is the defining factor here. It's the secret ingredient that elevates just a casual exchange of words into a very heavy legal obligation. Okay, final question number 3. If a buyer replies, "We agree to buy," to a mere price quotation, does Section 2B recognize this as a valid acceptance? Think about poor Mr. Harvey and his final eager telegram. And no way, because acceptance is logically only possible when a valid proposal exists in the first place. No offer literally means no acceptance. The logic of Section 2B dictates that you simply cannot accept an offer that was never actually made. Harvey's final telegram was legally meaningless because, well, there was nothing for him to accept. So, as you can see, not every negotiation results in a contract. Think about your own daily communications, your text messages, your emails at work, your DMs. Are you actually making legal offers, or are you just supplying information? Once you start viewing your daily chats through the lens of contract law and the Harvey versus Facey ruling, I guarantee you will never look at a simple price quote the same way again. Thanks so much for joining me on this explainer, and keep learning.